Hello, Colorado Realtors. I'm Scott Peterson. Thank you for joining me for another edition of Legal Bites. It is summer 2022, and it's hot out there. It's been a hot July. The summer's flying by way too quick for me, so I'm doing this in short sleeve because I'm going to take advantage of this nice warm weather. People have told me I've gotten too, uptight and stodgy, wearing suits all the time. So I'm trying to, really push that whole reputation away. I don't need any of that. Anyhow, I'm starting off this new series on commission position statements, which were recently revised. They're not necessarily new, but all of them used to be CP 1 through 46. Now it's 1 through 29. They have been updated, revised, modernized, consolidated, as the numbers would indicate, a little bit of elimination. Some of them have become obsolete. So for a lot of reasons, the Division of Real Estate or the Real Estate Commission authorized the division or instructed the division to create a task force and go through all of the commission position statements, all 46 of them, and clean them up, make them better teaching tools, learning tools, a little bit more instructive and insightful. And if you haven't checked them out, you should. There'll be a link to the Division of Real Estate's website just below this video. Click on that. It'll take you to a landing page where all 29 position statements you're able to download in a PDF kind of format and check them out. I think they've improved dramatically. And so, again, really nice teaching and learning tools. We're going to start. I'm not going to necessarily go in any particular order, and I'm not going to do all 29. Don't worry. I'm going to just do one by one and probably a handful. I'm guessing by the time this series is done, I'll hit 8 or 10 of the commission position statements in total. I'm starting with number 2 today here, and going to talk about broker commissions in Colorado. All right. It's actually CP2 brokerage commissions is what it's called. I added referral fees because it addresses referral fees as too, and that's something that's really important and a lot of confusion. In fact, so much confusion specifically related to referral fees, and I think there's some good instructive language in here, and hopefully we can clarify what is a complicated and largely misunderstood issue, and I know that based on the volume of hotline calls that I've had for years on that particular matter. First of all, let's understand what a commission is. A brokerage commission is what is paid for performing a brokerage service or brokerage function on behalf of somebody else, okay? That's not a referral fee, it's a commission. And so we know because it requires a brokerage service or a brokerage function, and the only people who can perform a brokerage service or brokerage function would be a Colorado real estate licensee, then commissions are only going to be paid to existing, active Colorado real estate licensees. So that's commissions, and that's pretty straightforward when we refer to commissions. That's a commission that negotiated with a seller or a cooperating commission, maybe paid by a listing brokerage firm to a cooperating buyer broker. Those are commissions, requires an active license. The stickier area or the more confusing area comes when we start talking about paying referral fees and understanding who can I pay a referral fee to, who can't I pay a referral fee to. I think there's a perception that you can only pay referral fees to licensed individuals, either in the state or outside of the state. And that is not entirely true, although it is true in most of the situations. And so CP2, this Legal Bites, is going to be tied to CP3. You got to watch them in connection with each other so that you understand the full picture. But I'm going to start off, because CP2 does, only talking about Colorado law as it relates to referral fees. We will have to worry about federal law, specifically RESPA, the Real Estate Settlement Procedures Act. But for the purposes of Colorado law, we need to think about just this. You can pay a referral fee to an unlicensed individual, or a licensed individual as well, but an unlicensed individual where a lot of the confusion comes up, in the event that reasonable cause exists. A, and B, that it's compliant with federal law, which is RESPA. So I'm going to come back to the RESPA piece, but let's talk about reasonable cause real quickly. And a lot of brokers just believe that, this is all there is to speak to, but you always have to consider the federal law implications when it applies. All right? So reasonable cause exists when, in Colorado, an actual introduction of business is made. That would create reasonable cause to pay a referral fee. Or a contractual referral fee agreement exists. That would create reasonable cause to pay a referral fee. Or a contractual cooperative brokerage agreement or relationship exists. that would be reasonable cause to pay a referral fee. Now, number one, actual introduction to business made, probably the most common, right? You're going to pay a referral fee to somebody who actually introduces you to the business that you actually end up closing and receiving a commission on, and you pay somebody a referral fee for doing that. Or potentially there's a contractual agreement, a referral fee agreement. Sometimes both one and two are present in most cases, and probably should be in most cases, that you've got not just an agreement or an actual introduction of business, but you've also got hopefully a written referral agreement to support that as well. The cooperative brokerage relationship, that's not a cooperative commission. That's not a cooperative commission that would be paid to a cooperating broker. That would be a commission that that would be a referral fee that would maybe be structured within, maybe two different offices of one brokerage firm might have a cooperative referral fee agreement based on, for a piece of business that was sourced by one firm and or by one brokerage office, and the other brokerage office actually perform the brokerage functions on that, and so they would be paying a referral fee. So less common in that third scenario, but any of those three things or any combination of those three things would create reasonable cause if it's compliant with RESPA, right? That's the big piece of things, as well as the fact that there can't be any brokerage functions performed by the unlicensed individual receiving the brokerage fee. We know that because in order to, again, perform any brokerage functions, you've got to be licensed in Colorado, not in some other state or unlicensed, period. You couldn't simply perform any brokerage functions. So as long as all of those components are present, a referral fee is fine. Now, RESPA is going to come up, though, in a lot of cases that are transactions that you guys are working on. If it is a residential property and there is a loan, a federally related mortgage loan involved, then RESPA, federal law, is going to apply. And that complicates things, or really restricts things, candidly, quite a bit. We're going to talk more about that in CP3 in the next Legal Bites when I do that. But for the time being, understand that Colorado law in and of itself or by itself is pretty broad. So if it's a land deal, if it's a commercial deal, if it's a cash deal where there's no loan involved, anything like that, then you only have to worry about Colorado law. You don't have to worry about RESPA. But if there's a loan involved and it's a residential property, you have to add RESPA to the mix, and that's where things get tripped up, okay? So again, stay tuned for the next Legal Bites on a little bit more with regard to RESPA. The last thing I want to address, and that CP2 actually addresses here, is paying referral fees to out-of-state brokers. So somebody who is licensed in another state who refers you business in the state. Number one, obviously, they can't perform any brokerage functions because they're not licensed in Colorado, which is why they're referring it to you to perform or to use your license to perform brokerage functions, all right? But totally fine to do, no problem whatsoever to pay somebody out of state who's licensed a referral fee, as long as there is an actual introduction of business made, as long as that person is actively licensed someplace in some state, as long as that person who's actively licensed in that state lives and does business or works in that state, okay, and they perform no Colorado brokerage functions whatsoever. And then finally, the other nuance to this, and this makes sense because we know that brokerage or the referral fees are paid brokerage firm to brokerage firm, not broker to broker or individual to individual. Brokerage firm to brokerage firm is how they're paid. The funds are received in the case of an out-of-state referral fee. They're received by the Colorado brokerage company who's paying the referral, and then they're distributed from the company to the other brokerage firm, right? So that's an important little piece when you're paying an out-of-state referral fee to an out-of-state licensed broker, is that the Colorado brokerage is recognizing or acknowledging the receipt of that entire fee and then distributing the referral fee from that pot, okay? So that's where we're going to leave CP2 for today, but you can't just watch this alone and say, yeah, I can pay referral fees to unlicensed people, because the RESPA piece, it complicates things. I'm going to address that in the next edition of this series when I touch on CP3. I'm doing this series thing because I find that, not unlike Ozark or Breaking Bad or, all these great hot series where, people are just hanging on for episode after episode. I'm trying to create that energy here. And I'm not sure it's working, but I'm trying, all right? So stay tuned for CP3 and the next edition of Legal Bites. In the meantime, if you have questions, Car Legal Hotline is available 9 to 12 and 1 to 4, Monday through Friday, and we always love hearing from you there. Take care, and we'll see you on the next edition of Legal Bites.